coordinate just so that we can send out the session to anybody who's been unable to make it. But I'm sure that's fine with you all. So we are both Make and Bhayani Law, and we have all previously supported charities quite heavily, and we are quite passionate about doing so. And so we decided to come together to create a network to enable people to learn from one another, from sector experts, to share any challenges, and basically to build supportive peer connections, which is why we've created our charity HR hub, and we're very pleased that you're all joining us. Today, you've got myself. So my name's Catherine. I'm the head of HR services at Bhayani HR and Employment Law. And then Lucy, I will let you introduce yourself.
Oh, that's me. I realised on my Zoom I've just got Lucy, very informal. I'm Lucy Atherton. I'm a solicitor with Make UK. I've been here for a very long time. I'm the head of HR and legal based in the London office.
So, oh, there's somebody else just arrived. We'll admit them. So we're going to go through some content with you, Lucy and I, and then at the end there will be the opportunity for people to ask any questions that they feel that they would like to ask. If you do have any questions during it, if we can ask that you pop them in the chat, and that way at the end we can gather up all of the questions and answer as many of them as we possibly can. Okay. So today what we're covering is legal aspects of recruitment, some tips on how to secure the best talent in a competitive market, rewarding and retaining staff and volunteers, what candidates really want, and then we're going to finish up on the Employment Rights Bill, and we're going to talk about proposed day one rights, amongst a few other things, I believe, Lucy.
Depending on time, we can talk about anything you like on the Employment Rights Bill.
So I'm going to hand over to Lucy to make a start, and she's going to talk through the legal aspects of recruiting.
Thanks very much. Oh, there's a poll before I even start. So they're being launched in the background. What's the biggest recruitment challenge for charities right now? Fairly big question for you there. I think this is useful to kind of help us map out how we help you in the future, what other networking events would be helpful, and what we can cover in future webinars. I think Alice is running this in the background, isn't she?
I am, yeah, sorry. I can see people completing it now.
Good.
Brilliant. So I think if we end poll, can everyone, if I share the results now, can everyone see?
Yes, I can.
Yeah.
So looking at the results, managing pay pressures is the biggest. Motivating volunteers, that's interesting. Second place, and a joint last or joint third, recruiting and retaining staff. Thank you for that. Catherine, I'm sure will be able to give some of her insight into that as well when she comes on to it. So let's move on to the legal nitty gritty. If you could move on to the next slide.
That's you, Catherine.
Brilliant. So I'm sure many of you are HR professionals, been involved in recruitment either in your current role or a former life, and you know how important it is to be aware of the principles of good practice, and in particular the legal area that bites in terms of recruitment is going to be discrimination. And running over the basics, obviously it's unlawful to discriminate against somebody in the arrangements you make for deciding who to offer employment to, the terms on which you make that offer of employment, and equally by not offering the person employment. In addition to the kind of legal frameworks, which is the Equality Act, it's also worth having at your fingertips, not really, but bear in mind that there's a code of practice from the EHRC which covers discrimination, has a big section on recruitment. So in terms of that's your kind of legal framework. The code of practice isn't legally binding, but if you've ever found yourself in a pickle in the employment tribunal, then it can be used as evidence in your employment tribunal proceedings. So it is a very useful document, although not necessarily legally binding. It can be taken into account by tribunals and courts. The first bullet point is pretty obvious, I think. Obviously, charities are not exempt from the rules. You do need to comply with the equality legislation, whether it's discrimination, harassment, victimisation, all those kind of issues melding through into recruitment. And this permeates into job design, advertising, selection, interviews, etc., etc. The whole recruitment process is impacted, and you have to be mindful of the rules around discrimination. The second point really is just me mulling over the complexities that charities in particular might have when you're trying to possibly balance your kind of mission alignment, so your kind of mission statement, your kind of charitable ethos with the discrimination risk. And in particular, if you're trying to kind of balance the values of a particular candidate or your values, and making sure that you don't kind of drift accidentally into unlawful criteria, which are pegged or unlawfully selecting or choosing, and inadvertently, subconsciously, whatever the case may be, or quite deliberately but erroneously, unlawfully discriminating based on a particular protected characteristic. So that is it's relevant to all employers, but I think probably is a bit more complicated for charities who have a strong particular ethos. So usually what happens is that if you're in that predicament, you're in that balancing, you're looking to rely on what we call genuine occupational requirements. So that essentially is a defence in employment law. It's a defence under the Equality Act. So that essentially allows employers, in fairly limited circumstances, I think we'd say they're very narrowly applied, but it does allow you to require a job to be performed by somebody with a particular protected characteristic, which is a bit of a mouthful for, as you know, sex, age, race, religion, disability, sexual harassment, sexual orientation, pregnancy, maternity, I think that's everything. But those are the protected characteristics of an individual. And so you are allowed in limited circumstances to select somebody for the role, or say the job needs to be performed by somebody with a particular protected characteristic. However, it's not a carte blanche defence. It can only be used if you can demonstrate that, thinking about the job, thinking about the nature of the work, that this requirement that you've imposed on the candidate, usually aligning with your particular charitable ethos or standing, if you're suggesting that candidate has to have that particular characteristic, you can only do so if it's and this is a legal phrase which is annoying but wordy, proportionate means of achieving a legitimate aim. So what's your legitimate aim, and have you approached it proportionately? Is it a fair and reasonable way of believing that the particular candidate needs these characteristics? And this genuine occupational requirement defence, such that it can extend to recruitment in relation to promotion or transferring within roles or training, and it kind of extends into dismissal as well, but we're not thinking about that today. So situations where you might be coming across a genuine occupational requirement might be, I mean, the obvious, well, some of the ones that people trot out are things like needing a black actor to play Othello at the theatre, privacy considerations if you're thinking about attendance in a changing room, that kind of thing, although perhaps less so these days. Cultural or language specific roles, you may need somebody who is a particular health worker for a particular group of nationals. You might want them to be served, or the caseworker to be of that particular same faith or racial nationality. So there are obvious reasons for why you may be wanting to appoint or choose a particular candidate with particular characteristics, but please remember that it is quite a narrowly applied defence, and you need to have a genuine business need and no less discriminatory way of achieving that aim. And the tribunals are quite tough on getting employers who are relying on this defence to really explain why that role has to be performed by somebody with those characteristics. So narrowly applied is the message there. Next slide, please. I think Catherine will touch on this in more detail, because these are kind of more HR practical points, not so much legal points, but obviously the kind of discrimination weaves through all of these kind of elements of the recruitment process. You need to be careful when you're actually looking at your job description, defining the essential desirable criteria, making sure that you're not crafting a job description that acts inadvertently, indirectly disadvantages a particular group. You need to think about the language that you're using. there's no specific prohibition regarding, discriminatory job advert as such. But if you do publish something that is reasonably thought to be discriminatory because of a protected characteristic, then you're going to be on the back foot as far as the organisation is concerned. It will probably go towards showing discrimination in your recruitment practice. And obviously, in an inappropriate advert will have some reputational sensitivity. It might impact on any funding, or kind of the way in which stakeholders perceive the organisation. So it's not just the legal framework that kind of guides you when it comes to using the right language and thinking about the wording of your adverts. It kind of extends broader to kind of reputation. Obviously, avoid language that suggests, age-coded terms, recent graduates, suggest somebody who's young, that type of thing. But equally, if you are looking at particular types of roles which do need particular levels of experience, just think it through. You can justify your approach as long as you are deliberate and sensitive in your approach. I think if you are putting a language that is somehow you believe potentially risky, then just think it through as to whether it's absolutely vital and necessary. And I think the same point can be made in relation to the selection process, the criteria, the scoring structure, kind of the general prohibition about unlawful discrimination in the arrangements kind of extends into shortlisting and the selection process. So therefore think really carefully about how you assess the applications, what personal characteristics you're looking at. And if you are going to be going back to the genuine occupational criteria requirement again, then assess that at that stage as well. Next slide, please. Obviously, the first point is just really about references. I don't know whether it's still routine practice to seek a full reference. A lot of employers just get a factual reference these days, but if you're going to do that, be careful how you handle the information that you're given. Sorry, I just got some random pop-up on my screen. And then the second point really is how you think about your grants, your donations, your funding, how that can impact on your recruitment. Sometimes the fact that you're reliant on a particular source or some kind of funding contingency can sometimes lend, or the inevitably kind of believe that the recruitment needs to be on a fixed term or a project basis, and so you articulate that this is because it's linked to the funding, that the role can only be on a fixed term or a particular end-to-end project. If that is the case, then that you need to be very clear in the recruitment process that what the contingency are, explain it quite clearly to the candidate that it is a fixed term role because it's pegged to funding or something like that. And also, I think, certainly in the charity sector, that the funding and those key issues can very much impact salaries, and can obviously sometimes limit salary potential, and therefore you might be straying in eventually into the world of equal pay. So just be mindful of how all those kind of funding issues can impact on the recruitment of the candidate and the salaries on offer. Last point, I don't know how quickly I can deal with the whole of data protection, but basically data protection does, in fact, I might say, permeate, better, more positive example, throughout the recruitment process. There's a bajillion things to think about when it comes to data protection. Obviously, your fundamental framework for data protection compliance is adhering to the kind of principles of fairness, lawfully processing the information that you receive from your candidate, being transparent about the way in which you'll manage their data, thinking about the privacy notices. At what point do you provide your candidates with a privacy notice? What is your basis for processing? We could have a whole session on data protection, but remember that the charity is a data controller, so bring in your normal data protection considerations and compliance throughout the recruitment process, and make sure that you don't forget that. It's easy to focus on discrimination, but there are lots of other underlying legal principles that weave through here. One of the issues is, I'm not sure how much impacts those on the call, but possibly safeguarding and criminal records checks. There are rules around criminal record checks embedded in data protection compliance, but also it's broadened out into safeguarding more generally. If any of your staff and to some extent volunteers, which we'll look at in a minute, are in contact with vulnerable children or adults, then you will need to think about whether it's appropriate to have a DBS check, and if you are going to be doing that, can you properly handle the information that's received sensitively? You might be thinking about whether you have to conduct a risk assessment based on the role, as to whether a DBS check is appropriate. And obviously the obvious one in the world of criminal records is don't, be mindful not to unlawfully discriminate on the basis of someone's spent convictions, because of those are protected separately. So if you're in an environment where you are dealing with vulnerable adults or children, or you may be an organisation where you're advocating for you have a positive policy towards employment of ex-offenders, then just get that balance right. Think through the kind of criminal records and safeguarding issues in your organisation. Next, please. I imagine most of you have volunteers to some extent. They may be performing a variety of roles within the organisation. Helpfully, there isn't really a definition of what a volunteer is. There's some links to it in the Police Act when it comes to criminal records. The government guidance talks about somebody who's got an arrangement with the organisation. It doesn't leave them financial award. They don't have to turn up. If they don't want to, they can't be dismissed. They can't be sued for breach of contract, that type of thing. So you kind of know a volunteer when you see one. You think it could be a PR expert, it could be a fundraiser, or it could be somebody who's working in the charity shop. And the range is quite broad. Because it's not a clear-cut definition, the legal status of a volunteer can vary considerably as well. You might have somebody who really is an employee on an employment contract, or you may have somebody at the other end who is genuinely a volunteer and does not have an employment contract. And this kind of weird ambiguity, this kind of lack of clarity, makes it difficult to give with any certainty what the legal obligations and rights owed to this class of individual is. So you'll remember that broadly there are different categories of individual in the broad sense employment relationship. You've got employees who have a full employment contract, and obviously they're protected from unfair dismissal and the raft of legislation. Then you've got a smaller category of worker who have the right to be paid the national minimum wage and holidays, but not protected from dismissal in the normal way. And then the discrimination legislation has this kind of hybrid category, a slightly wider category of person, but they all rely on having a contract. So the key thing with assessing the status of the volunteers, as you might call them, is thinking, do they have a contract? And so the component parts there are, is the work done in person? This concept of mutuality of obligation, that's important for an employment contract or contract. So, is there an obligation to provide work and an equivalent obligation on the individual to do it? This kind of mutuality of obligation is very important. What control do you as an organisation have over the work and the individual, the way that they're doing it? In the world of volunteers, there is inevitably a bit of mutuality of obligation. It's unusual for you not to have some control over the work, but it's understanding how those tests feed into the big picture of what this individual is doing. So you're really looking for a contract underlying this and assessing what that contract is. There've been bags of cases about volunteers. Some have said that, a volunteer in the Citizens Advice Bureau is an employee. Some have said the exact opposite, said no, they're a volunteer. There are lots of factors at play here, and it's quite case or fact specific, but there are some threads that you pull from the case law. So it would be not unusual to have a set of guidelines or standards that you would expect your volunteers to follow, even in the absence of a contract. And I think the case law is quite clear. You can have some expectations, you can have some standards and guidelines, and that in itself doesn't mean you've got a contract of employment. It's really important to think about the payment structure and how that impacts on the status of the legal status of the volunteer. You need to be aware that as an organisation, even if they're a genuine volunteer, you can still possibly be liable for their unlawful acts. So it's important that you have insurance that covers all your employed staff and your volunteers. And that equally means that you should ensure that they're covered in any kind of equality training that you have in the organisation. Don't exclude your volunteers. I would include them. And then the health and safety obligation extends to your volunteers as well. And the last point on there is to have a carefully drafted volunteer agreement. Now, I'm not saying you have to have a contract or a volunteer agreement, but I think it can really help you define the legal status of the volunteer if you have a volunteer agreement. Next slide, please. And so if you're going to have a volunteer agreement, or you want to create an arrangement that doesn't lend itself to an employment contract, these are kind of some key risks. You can't potentially avoid all the risks, but these are kind of things that you need to think about. So avoid making any payments to your volunteers that might be thought as to be wages. That's a slam dunk own goal. If you're paying people wages or something that looks like wages, then they are not a volunteer. So you can have expenses, and if you're going to have expenses, they need to be really clearly identified as such and covered by the kind of receipts expenses process, not a regular payment. Don't impose a kind of obligation to provide work and volunteer to carry it out. That's that mutuality of obligation. Allow the individual to the freedom not to turn up. Annoying as it might be, you might have a rota, a schedule, and there's an expectation or hope that these individuals will perhaps routinely work up Wednesday morning, but do not impose too strict an obligation on them. They should really have the freedom to refuse work and potentially training. But obviously you need to make sure they have the right skills to do the job. So that's a balance. And that ties into the next point, giving them a choice about when to work. That will help point away from a legal contract. And then the last point really is just think about how you communicate in the language that's used when you're looking at volunteers. Using ifs and suggested or usual helps rather than being too prescriptive and specific. Next slide, please. I think this is probably my last one. So that was just kind of the kind of legal issues underpinning volunteers, and this is to just kind of bring it back into the world of recruitment. Although they are volunteers and not hopefully your employees under a contract of employment, and they're not necessarily covered by discrimination legislation. They're not protected by the discrimination legislation the same way as your staff are. It is still good practice, in my view, to adopt the similar criteria for selection for your volunteers as you would your employees. If you adopt a fair recruitment process, and think about the discrimination obstacles or risks for regular staff, then I would do something similar to volunteers. They may not be able to bring a claim for unlawful discrimination if you didn't appoint them, for example, or you didn't take them on. But I think it's good practice to be ensuring that the procedures and policies are similar. And then my last slide is there. When you're thinking about the kind of policies and procedures you have in your organisation, you wouldn't necessarily expect the discipline and grievance procedure to extend to volunteers, but you would expect the quality anti-harassment type of those policies and procedures to cover volunteers, and certainly training, as I mentioned before, in relation to equality. I'd expect that to extend to volunteers. So although they're not your staff, they're not protected in the same way, you don't have the same responsibilities or duties owed to them, do scoop them up in some of the sensible anti-harassment, discrimination, equality act training that you have within the organisation. You may have a volunteers handbook or something like that, but the more you embed them in the same process and procedures as your staff, that's the bigger evidence that you're treating them as an employee, and you don't really want to go that far, but don't ignore them completely. It's going to be really important that they are picked up in your equality policies. I think that's it for me, Catherine. I've probably talked about lots of things we're going to talk about.
No, that's quite all right. It saves my voice, doesn't it, after all? So I'm happy for you to carry on. So now I'm going to take over from Lucy for a short while, and we're going to talk about securing the best talent in a competitive market. The landscape out there is very challenging for all sectors, really, in terms of recruitment at the moment. But I think that is particular in charities, where you do struggle to get the best talent for whatever reason that might be. And so it's about thinking about what you can do as part of your recruitment process in order to try and not only attract but retain that talent. So the first thing that you need to think about is fair selection and onboarding. Now, I know that Lucy's already covered all of the elements of discrimination and equality, which are all incredibly important, obviously, from a legal point of view. But a lot of feedback that we get when you're thinking about fair selection is that something that candidates do look for is a consistent approach, fairness, and just being made to feel as though they are being recruited in a fair way and a transparent way. So I know Lucy's already picked up on it in terms of the discrimination element, but we very much recommend from a HR point of view that you use structured interviews and scoring systems, and that you're quite transparent about those, because transparency is important when you think about the context of charity. And it makes people feel like they are being treated properly. Avoid gut feeling decisions, and that gut feeling can extend to, I've got a friend of a friend who needs a job, and so you take them on because you're better to have, you're better off having a warm body than nobody at all. But that can be a recipe for disaster for a number of reasons. Number one, you're not benchmarking it against the other potential candidates. You are also not opening yourself up to the potential of what may very well be better candidates if you are limiting it to either gut feeling decisions, or friends of a friend and things like that. Lucy again has already covered it, but when you're thinking about your notes, make sure that they are GDPR compliant in terms of your record keeping. So make sure that you are looking at your data retention policies, that you are only keeping them as long as is required, and that they're being securely destroyed at the end of it, and that you are treating that data sensitively and in a way that you should. Offering reasonable adjustments. This is something that we always recommend that you would do, whether that adjustment is to do with the actual environment in which they are being interviewed within, whether that is to do with how that interview is undertaken. It may be that you've got somebody who's neurodiverse, and it's easier for them to do a verbal application rather than a written application, or it may be to do with dyslexia. So there's lots of different reasons why people may need reasonable adjustments. So it's a good idea to put in probably your adverts that if anybody requires any reasonable adjustments, then please ask. And also it's going to tick that discrimination box as well, because ultimately if people don't ask for those adjustments, then you can't be expected to provide them. And then you need to think about your onboarding processes. Inconsistent onboarding can lead to people leaving. We get a lot of people that we deal with, because we deal with not only organizations but employees as well, that say that when they started, that they didn't feel like they were treated properly, that they were maybe made to feel uncomfortable because they weren't onboarded, and it just made them feel a bit like it maybe wasn't for them, and so they've moved on. So always think about your onboarding and your induction processes from a legal point of view. Are you doing what you should be doing? But also from a people management point of view, you want people to be made to feel welcome. So does anybody think about employer brand when they're thinking about their how they attract talent? And I think this is something that it's very easy to forget about, but you are selling yourself as much as the candidates are selling themselves to you when they ultimately get to interview. And so it's really important to think about your employer brand. Your employer brand should be built on your mission and the impact that you want to have. So everything should go back to your charitable obligations. We recommend that you tell real stories and case studies. A lot of people who go into working with charities, it's because they care and they want to make an impact in whatever area it is they choose to go into. And so often having real stories, using storytelling to promote roles, people want to feel good about where they work. So if you've got other people that are in the same or similar roles that you can do, that are happy to do kind of testimonials, whether that's written, whether that's video, get them out on social media, because then you're going to get buy-in from your applicants and you're going to potentially get better people. It's a good idea to partner with volunteer networks and community groups if you don't already. Now, a lot of your labour market might be held within your pool of volunteers. So it might be that they start with you as a volunteer because they only want a part-time role, a job at the, you know, at that time, or they're doing something else and they just like to give their time. They might be at school, they might be at university and just wanting to you know, to spend time helping charities, but they are potentially going to be your pool of candidates. And so the more volunteer networks you're part of and the more volunteers you have, the wider the labour pool is potentially going to be, or the deeper. And the biggest thing these days that we're seeing, not only in charities but across all sectors really, is people want flexibility and they want their well-being benefits. There's no getting away from it. And so the more that you can showcase what you can do in terms of your flexibility and well-being, what do you offer, what hybrid policy have you got? If you can showcase that within your advert, then that is really going to be bringing people to you. And I think one thing that we do as an organisation, and I think charities especially should do, is also think about their values. Values should be woven through everything that you do, and that includes the application process, the adverts and everything like that. So think about how you can weave your values as clearly as possible throughout your job description and then through the interview process as well, so that A, you're showing what your values are, and B, you're making it clear that your values are important to you, and as they, you know, if they are successful in the position, then it will be expected to be important to them too. So we've got another poll, which I think Alex is going to organise right now for me. So what do you think makes the biggest difference when it comes to retaining people in the charity sector?
Yeah, I've launched the poll, by the way, so just waiting for people to.
Thanks, Alice.
Right, I'll just end it now. Oh, hold on, a few more are just coming through.
Oh.
Right, okay. Oh, still some more. Right, I'll end it now and then I'll share the results.
Okay, so opportunities for development and progression. Yeah, and I think that isn't necessarily just limited to the charity sector. It's something that we see a lot, especially if you're a smaller organization. Obviously, you know, there's only so far you can go within a small organization, and a lot of charities are smaller, aren't they? You've obviously got your national ones, which that's great. You're going to have your opportunities for development and progression. But equally, I think those smaller ones, it is a massive challenge, because you want people to be able to develop and progress within their career. But if you can't offer it, you can't offer it, can you? So next slide is reward beyond pay. This kind of is an extension of what we were just talking about in terms of what can you offer. People these days, candidates these days, are looking not only at what their salary is going to be, but also what are the other things that are also considered to be reward. And these are the things that maybe you can offer which are going to attract people. We know that most charities can't match the private sector salaries. You know, we know that they can't give the bonuses or the commission, you know, payments that a lot of other sectors can offer, but you can offer meaning, you can offer flexibility, and you can offer a positive culture. And even low cost rewards, things like wellbeing days or public recognition, or, you know, volunteer days to volunteer somewhere else in another charity, that can really build engagement. So recognition and appreciation is something that I think a lot of people don't realize how much it is appreciated. And so that can go a long way. We've already talked about flexible and hybrid work. That's here to stay. It's not going anywhere. And people expect it these days. If their role is able to be undertaken in a hybrid fashion or a flexible fashion, then people are expecting that that's going to be allowed. Extra leave or well-being days, you might not be able to match the salaries, but can you give them more annual leave? Can you offer them the opportunity for a salary sacrifice to be able to purchase annual leave? What can you do around leave, which is going to promote your charity to potential applicants, because work-life balance is what people are really thinking about, and obviously time gives you that work-life balance. Professional development, we've just said in the last poll, haven't we, that professional development is one of the biggest challenges when it comes to retaining. So think about what you can do that might be an alternative to a promotion, because development is not necessarily a promotion. Can you think about an additional initiative that somebody can work on, give them a project to work on that's going to develop them in terms of their skill, but also it's going to give them ownership of something? People consider that to be development as well. And again, what you need to have is a supportive culture and autonomy for people to be able to do the best job that they possibly can. And it's always a good idea to benchmark. I don't know who does benchmark salaries, whether it's something you actively do. There are tools out there that can do it, or you can get somebody like ourselves or Make to do a benchmarking project for you. Because whilst you might not be able to match the private sector salaries, what is important is that you are competitive within your sector. So retention and engagement. So we often find that staff and charities cite burnout and lack of opportunities as reasons for leaving. And so when you're thinking about retention, it's about how can you combat those issues. So engagement surveys, if you don't already do them, are always incredibly helpful, not only with your employees, but also with volunteers. The volunteers are often, your feet on the ground, and they will potentially see more than other people. And also they often undertake, the more arduous roles in terms of, going out and doing your fundraising, helping at events and things like that. So it's important to keep them engaged, and it's important to understand that they are happy and content, because without volunteers, a lot of charities simply wouldn't be able to function as well as they do. You need to foster inclusion, and you need to foster belonging. People need to feel like they're all on the bus, that they're all on the same bus. And if you've got those outliers that maybe aren't, then that's when you need to look at your people management. If you've got people that aren't on that bus, what the knock-on effect of that is toxicity, or it is people not feeling like they that you are instilling your values all across the organization. And so it's always a good idea to look at the people that are maybe outside of your values and your mission. Recognizing contributions, again, that's incredibly important. Managing workload. I think what often happens is if somebody's doing a good job, it means you give them more tasks, and you give them more tasks, and you give them more tasks. That's where burnout comes into it. So you need to make sure, as leaders of the charities, that you are managing people's workload and therefore their well-being, and also empowering your managers to be managing their team's workload as well. And critically listen and act on any feedback. There is no point in having engagement surveys or interviews or feedback loops or anything like that if you don't act on it, and people will become quite disenfranchised if you don't. Okay, so Lucy, I think you're back up. You're going to be talking about the Employment Rights Bill.
Yes, and we're going to extend this session for another 5 hours so that I can just quickly run through the Employment Rights Bill. No, we just thought we'd do a quick poll first, and ask which part, to the extent you know anything about the Employment Rights Bill, which do you think will have the biggest impact on your organisation? And we've just picked a couple of ones there for the moment: day one and fair dismissal rights, guaranteed hours, or the new shift notice cancellation requirements. Feel free to tick that "I'm not sure yet" button, because actually you would not be alone in that situation.
That would be the one that I'd be ticking, to be honest.
I would be ticking that one, absolutely.
Just waiting for a few more to answer, and then I'll share the results.
Thank you, Alice. I thought you'd all just go straight for that. I'm not sure yet. I don't know much about the ERB.
Right, I'll share the results now.
There you go. Most of you, the majority of you are not sure yet. Good. That's good because we can tell you all about it and you have potentially some time to get your head around this. Next slide, please. So there are a million things changing under the Employment Rights Bill. And we just picked a couple to cover today. There was lots of information, certainly on the Make website. My team have been producing what we call spotlights. We have an ERB hub, which we are maintaining with all the consultations that are being issued, all the brief outline of the topic, the HR considerations for each change. The million-dollar question is, when is it going to come into law? And we expect it to be October. It's probably going to be early December. There's some sticking points between the Commons and the Lords. They're playing ping pong. It's back in the House of Lords next week, I think. So it's not yet in force. It's not received royal assent. And then the key thing to remember is, even when it becomes an act, an Employment Rights Act, the implementation of all these gazillion proposals is really staggered. For example, the unfair dismissal provisions likely to come into force in 2027. Not much is happening very soon. There are some April changes to do with statutory sick pay, for example, but the bulk of the big changes are being pushed back to certainly the end of 2026, if not 2027. So you have time to get your house in order. You have time to learn all about it. But I just thought I'd spend a couple of minutes just highlighting the key issues with unfair dismissal. Obviously, at the moment, employees have to have 2 years qualifying service to claim, I say, ordinary unfair dismissal. There are exemptions for certain other types of dismissal, like discrimination and whistleblowing, where you don't need that service. But for regular unfair dismissal claims, the ex-employee needs to show that they have 2 years service. So what's changing under the bill? This is a big sticking point. The government manifesto pledge and commitment is to remove that qualifying period, calling it day one rights. But the sticking point is whether, in fact, that is acceptable to those sitting in Parliament. What it would mean if you remove that qualifying period is that you, as an employer, would need to establish a potentially fair reason for dismissal, which you do anyway for the majority of your exiting employees, but you'd have to do it from day one, and that you acted reasonably. So you're still looking for a fair reason for dismissal. You still got to act reasonably. And the point is, those principles kick in much earlier for every employee, no longer how long they've been with the company. As part of the changes that are going to be introduced, there's going to be this new light touch process. Some people are calling it a statutory probationary period. It's not really referred to that in explicit terms, but essentially what is expected to happen is that there'll be a period likely to be 9 months, although they're going back and forth about that, whereby employers adopt a light touch to the exit. Exactly what that means remains to be seen. It doesn't extend to redundancy dismissals or some other substantial dismissals, but for the key kind of conduct capability dismissals, you will have an ability to exit them by following a lighter touch process than you would for your staff who've got longer service. Whether that's remotely valuable to employers to have this light touch process for some and the full blown fair procedure for others, it remains to be seen whether that's remotely helpful. But it will be there as a kind of opportunity for you to essentially exit somebody more quickly if they're in this statutory probationary period of potentially 9 months, and there will be potentially a lower compensatory regime applicable if someone is successful in bringing an unfair dismissal claim in that process. Lots of ifs and buts about how that's going to look like, but it will be a significant change to most people's procedures. And when you're looking at kind of the HR considerations that might flow from this change, I think it's probably likely that there'll be an increase in tribunal claims against organisations if it's easier to bring a claim because you have the relevant service, or you don't fail by not having the relevant service. Then potentially the tribunal is open to more people who leave the organisation. It's open them to complain that you acted unfairly or there wasn't a fair reason for dismissal. So we think that's a likely issue. Needless to say, you're going to have to look at your policies and procedures and have a big review of them, consider your use of contractual probationary period potentially, think about what processes will need to be considered, whether it might be performance management procedures need to be tweaked, your attendance conduct processes need to be reviewed, your line managers or anybody managing staff, particularly those who are handling dismissals, will really need to be trained to ensure that they know that the new rules or the impact of the new rules. Essentially, it's going to be hard to dismiss somebody early on in their service, even if there's a light touch. So, you know, getting everybody up to speed on that. As I said, likely implementation is 2027, and there's a lot more to learn about how it's going to work before then. So eyes peeled. The next and my last slide is just to highlight the potential changes on 0 and low hours contracts. When we were debating what to cover today, we felt that some of the organisations we work with do use 0 hours contracts, so it's worth flagging it for the session today. It may not be something that you regularly use, but at the moment there are very few legal requirements around the use of what we call 0 and low hours contracts. Organisations obviously use them often to manage fluctuations in work, seasonal, that type of thing. And there's no real requirement to provide regular work or regular patterns to these individuals. Now, the government's a very sensible stated intention is to end exploitative use of 0 hours contracts and end that one-sided flexibility. And the kind of bugbear for employment lawyers is this term exploitative use, because you can't really manage the use of 0 hours contracts and end the perceived villain of one-sided flexibility and just narrowly target at those big bad employers who use them exploitatively. Because if you're going to change the rules, it applies to everybody. So those people who are reasonably using 0 hours contracts, their staff, the individuals who are working under them are content. It's a fair and decent approach to a situation and workforce. They're all going to be swept up. It's not narrowed down to the exploitative use, but that was the stated intention. The reality of all of this, I'm sorry to say this, is that the rules or the changes in the Employment Rights Bill are fiendishly complicated about the 0 hours and low hours provisions. There's again, like a bit like the unfair dismissal changes, there's a lot more to come. A lot of the information about what is going to be classed as a low hours contract, what notice requirements are you going to be required to make, what does a guaranteed hours offer look like, all of that is going to be contained in what we call secondary legislation. So even though the act will come into force possibly December, a lot more of the information is going to be set out in subsequent regulations, which you haven't seen. There's government consultations galore on the Employment Rights Bill at the moment. There will be more consultations about the use of this. And this is a sticking point in the House of Lords at the moment anyway, so it may even change in its approach. But broadly speaking, employers will need to offer individuals who are working on individuals who are on a 0 hours contract, they're going to be required to offer them a guaranteed hours contract. And that's going to reflect their kind of regular pattern of work. So you look over a reference period of, we think 12 weeks, look at the pattern that the individual has been working and make them an offer, a guaranteed hours offer of that pattern. The format of the offer and how long the offer remains open, that kind of thing, all going to be dealt with in the regulations. It picks up not just 0 hours workers, it picks up people who are considered as low hours contract workers. We don't know what low hours means. Is it 2? Is it 10? Who knows? All going to be decided later down the line. The worker doesn't have to accept this guaranteed hours offer. They can continue on the same terms as if they're happy with it. It extends to agency workers in a particularly tricky fashion, so let's not go there today. You can contract out if you work with a trade union around it. And then there's this possible payment element. If you have a new contract and you change the shifts without reasonable notice, then you might be hit for a penalty. A kind of a payment will be due to the individual. That's quite light in terms of information about that at the moment, but potentially this kind of short notice is going to be a tackle. So employers are going to have to provide reasonable notice of change of shifts. So it's all quite tricky and complicated. I think the main thing for you to think about now is it's going to be a while before this comes in, but if you are an organisation that does use, let's call them flexible labour, so individuals who are on 0 hours contracts or minimum hours contracts, that type, even annualised hours contracts, or possibly even fixed term contracts. Think about that kind of pool of labour in your organisation, and assess and kind of map out which parts of the business use that kind of type of worker, and then think about how the changes might impact on that. Will it really restrict your recruitment abilities? Will it really inhibit your flexibility, your work patterns? Are there certain contracts that need a particular flexible labour force to deliver it? There will be record-keeping obligations, as there will always be in this type of thing. If you have a trade union in your organisation, you can work with them to kind of hopefully make this a bit more straightforward. And as I said, likely to happen in 2027, don't know when, whether it's middle, end, whatever. There'll be an awful lot more information on this coming out as part of the consultation, part of the regulations, but it at the moment is ridiculously complicated. And to some extent, the red flag is if you're using this type of contract in your organisation, be mindful that it's going to be very complicated to continue to do so in the future. So think more broadly about whether you can revisit some of your labour flexible, the way that you use that flexibility in the workforce at the moment, because it may well become more complicated in the future. I think that's everything I had to say, unless there's a surprise slide at the end that I forgot about.
No cheeky surprise slides. So just to let you all know, we are going to be, both Make and Bhayani Law will be undertaking safer recruitment training, or delivering, sorry, that's probably a better way of describing it. It's a half-day course that helps you to embed safer recruitment practices throughout the entirety of your hiring process. And it's going to be designed, either we can come in and do it for everybody, or line managers, whoever it might be. And please do get in touch with us at hello@Bhayani Law, or get in touch with Gail at Make, and then we can get you organised with that. Lastly, we have our Bhayani Law and our Make UK newsletter